Having come and gone, the House Judiciary Criminal Committee shall come to order. Madam Clerk, are we in receipt of any replacement letters? I don't believe so. Are we? No? Okay, clerk, please call the roll.
Slaughter,
Here.
Cassidy. Here. Windhurst,
Present.
Cabello. Davis. Freeze. Gonzalez. Guerrero Cuellar. Gazzardi. Morgan. Olico. Ryan. Sheehan. Tipsword. Vella. 14 members present. That's quorum.
Okay, 14 members present. The quorum is met. Let's get on to business. We'll hear 7 bills this evening. Representative Vella, we'll start with you and then followed by Representative Hernandez. I think I saw you here, and then Representative Laha. With that said, Rep. Vella, the floor is yours on House Bill 5020.
Thank you, Chair. Permission to present from my chair. So House Bill 5020 is a bill concerning extended juvenile jurisdiction. What that is prosecution of a hybrid system in the juvenile system where the responsibility of the state's attorneys. It does also address the age of the minor. However, we are currently in discussions with the state's attorneys and law enforcement that very well could bring them not just to neutral, but possibly in favor. We're just asking to pass this out of committee right now, hold it on second, and we'll be bringing it back with an amendment.
All right, thank you, Representative. So you want to move this to the second and hold to continue more dialogue before we move to questions. Let's get on to some witness slips here. You have 32 proponents. Cook County Public Defender, Illinois Justice Project, several individuals, Juvenile Justice Initiative, Cabrini Green Legal Aid, Chicago Appleseed Center for Fair Courts, Restore Justice in Cook County Justice Advisory Council. Representative, you do have two opponents slipping at the moment. Illinois States Attorneys Association and the Illinois Sheriff's Association. Members, questions on House Bill 5020. Spokesman Winhurst.
Thank you, Mr. Chairman. Representative, you mentioned there would be an amendment. Could you give us a preview of maybe a couple things we expect to see in that amendment?
Yes, we are tweaking some of the language around what the judge can consider when determining whether somebody is appropriate for EJJ. We're also looking at currently the law amends the age. We're looking at bringing the age back into where it was initially, which I think will take away most of the opposition, if not all.
Mr. Chairman, just a question about how we want to handle this today. Because there's an amendment, do you want us to wait on hearing from any of the opponents, or how do you wish to handle that?
Mr. Spokesman, I didn't catch all of that. What was?
Yes. Do you want us to hear from opponents now, or do you want us to wait on amendments that are coming back? What would you?
Let's wait on the amendments to come back.
Okay. So we will hear that amendment back in this committee then.
That's correct.
Thank you.
That's correct. Any further questions on House Bill 5020? Seeing none, Vice Chair Cassidy moves that House Bill 5020 do pass. And partisan leave granted. And there being 9 votes in favor, 5 votes opposed, 0 voting present. House Bill 5020 is declared passed and be fairly reported to the House floor. Thank you, Representative Vella. Representative Hernandez. Oh, there she is. I couldn't see you. Okay, the chair recognizes Representative Hernandez to present House Bill 4559. The floor is yours.
Thank you so much, Mr. Chair Slaughter, members of the committee. I'm here to present House Bill 4559, which is a measure focused on fairness, rehabilitation, and improving outcomes within our justice system. This bill was brought to me by the DuPage County Public Defender's Office and is supported by the Women's Justice Institute, Alliance for Safety and Justice, and many other organizations. Right now, individuals in pretrial detention often invest significant time in programming. They take initiative by participating in substance abuse treatment, work assignments, parenting classes, and other rehabilitative efforts, which is exactly what we want them to be doing. That's why several years ago, the legislature made sure that programming completed in county jails would count towards the same sentence credits as if it were completed in IDOC. Now, due to some appellate court cases, that said, prisoner in the statute doesn't include people waiting in trial in county jails. This credit is being applied inconsistently by trial courts, which HB 4559 addresses this confusion. This bill clarifies when trial courts may award earned sentence credits for programming completed in county jails. This is for people who are actively participating in rehabilitative activities such as treatment and skills program. This bill does not change anything about programming credits within IDOC, but these programs and credits are evaluated by the trial court at the time when someone is sentenced. This is more about incentivizing the right behavior early on and making sure that our laws are applied consistently across the state. When people are encouraged to participate in programming from the beginning, we do see stronger rehabilitation outcomes, better preparation for reentry, and ultimately safer communities. HB 4559 is a small bill with a big impact because it helps align our policies with what we know work, engagement, rehabilitation, and successful reentry. I would be happy to answer any questions. Also, Charlene Grace from the Cook County Public Defender's Office is available to help answer questions. I respectfully ask for your support.
Okay, thank you, Representative Fernandez. So, looking at how individuals receive sentencing credits during their time in county jail. Before we get to questions, let's get to some witness slips here. You have 39 proponents. Cook County Public Defender's Office, John Howard Association, AIDS Foundation Chicago, Lake County State's Attorney's Office, ACLU of Illinois, several individuals, Illinois State Bar Association, Parole Illinois Restore Justice Foundation, to name a few. You have one opponent, Chicago Lodge 7. With that, members, questions on House Bill 4559? Well, actually, before we get, did you want to provide testimony first? Okay. We'll turn to questions. Spokesman Winhurst. And Vice Chair Cassidy, followed by Vice Chair Cassidy.
Thank you, Mr. Chairman. We did not have this initially on our call list for today, so I want to make sure I cover this thoroughly and have clear understanding. This is dealing with credit for people who are held pre-trial prior to their being sentenced to the Department of Corrections. Do I have that correct?
Correct.
And while we are maintaining most of the current arrangement, we do change substance abuse or this bill does change substance abuse program from a full-time 60-day or longer substance abuse program just to substance abuse program. Is that correct?
Hi, Leader. Charlene Grace of the Cook County Public Defender's Office. You're correct about striking the 60-day requirement, and that is specifically an amendment in response to some case law that's we're seeing leading to really strange outcomes. So if someone has a program that's scheduled for 60 days, but they complete it earlier, some courts are saying that doesn't count if they have a program that's scheduled for less than that, but they take more than 60 days to complete it. So what we're seeing is that it's our agrees was generally intended to be available through past amendments to the statute, and we're also seeing a lot of inconsistencies across counties.
And it looks like we also add county jail or detention facility work assignments as eligible for credit. Is that right?
That's correct.
Parenting program, is that correct?
That's correct, and that was a request from Women's Justice Institute. I think we would all intuitively think that a parenting program was a life skills program or one of the other programs that was already enumerated. But what Women's Justice Institute found talking to incarcerated parents and specifically incarcerated mothers is that, again, inconsistencies because it wasn't explicit in the statute.
And then there's a last sentence in that section that's added that says the rules and regulations shall also provide that sentence credit may be provided to a committed person who participated in supervised community work or activities in accordance with a section 5-5-9 prior to his or her commitment to the Department of Corrections. What's the purpose behind that, if you recall?
I apologize. I actually don't have the specific motivation for that change with us today. I can say that we developed this language with the input of some of the appellate practitioners and the folks in DuPage County who are looking at this daily. So I apologize that I don't have a better answer. I'm happy to follow up with you after the committee later.
Thank you. And it appears that maybe there's also some credit for self-improvement programs, volunteer work, or work assignments that are not otherwise covered under other sections, kind of a general catch-all. Is that right?
I believe that's right, and it's our understanding that in large part, again, the statute was meant to create parity, so that whether or not someone was doing time in the county jail before they were sentenced or they are doing the same kinds of activities in IDOC after sentence, that the same kinds of sentencing credit would be available. So that's meant to, again, make sure that that's captured.
And it appears that we heard that Chicago Lodge 7 is opposed, but also the state's attorneys are opposed. Are you aware of what the nature of their opposition is? Okay.
Please approach the testimony table.
Thank you, Mr. Chairman, members of the committee. Mike Celeste on behalf of the Association. Um, we we appreciate the sponsors' work on this, and we very much want to be supportive of it. We do.
Hey,
Is my
Z,
mic
is
on?
your mic
Am I not speaking loud enough?
There you
I'm
go.
sorry. We do want to be supportive of it. Our request that was communicated via today, actually, to the advocates is there's no uniform standard for sentencing credit. And there are counties in this state that can't offer the program, that can't offer the types of programming that other counties can. We'd like to see a certification process. We're open to how that looks. If we could get a certification of the programming for each county in the state, because they're disparate in how they can approach this type of programming, I think we could be okay.
Thank you.
Okay, Spokesman Harris, does that conclude your questions for the okay. Vice Chair Cassidy?
Thank you, and thank you for bringing this. Just for some historical context, the original bill that we believed would lead to sentencing credits for folks in county passed unanimously in 2023. So we have already debated whether or not folks should get credit for the time they spend in pretrial. And honestly, you're right. Every county is a little bit different. One of the things we have in Cook is people who are going to end up spending the majority of their sentence pre-trial, and leaving them out of being able to access programming and access credit is simply, taking the brokenness of our system and doubling down on it. So I appreciate the desire to come up with some measures. I think that overlaying some sort of new process on 102 disparate counties might be a little overburdensome. But I hear what you're saying about the desire to make sure that the programming is appropriate. I don't know that I would go so far as to try to convince that many sheriffs and state's attorneys and court clerks to put themselves through the same evaluation process or something. But I'm open to some thoughts on what that looks like. But I want us all to remember that this passed unanimously in 2023. We were all in accord that county jails programming should count towards people's sentence credits. Thank you.
Thank you, Vice Chair Cassidy. And just to clarify, Mr. Zaleski, you were suggesting a certification program, right? In regards to this. Okay. Cook County Public Defender's Office, if you want to kind of maybe give your thoughts on a certification program, that would be nice. Before you do that, we're going to get a question from Leader Gazzardi.
Yeah, thank you, Chair, and thank you, Representatives, for bringing the bill today. I guess my question would be for Mr. Zaleski, just to your, is it your organization's view that the status quo would be preferable to the bill passing? It seems like the status quo is a situation of sort of uncertainty as to whether these credits should count. There's court cases that have led to uneven application of this law. So tell me why that situation would be preferable to the circumstance of the bill passing.
To be clear, Mr. Chairman, it would not be, but I regret it. I mean, I have an association of the state attorneys that both can allow the defendants to get this type of programming, and there are, quite frankly, a vast majority of counties where this programming isn't available. I think there's discomfort with an uneven application of what programming looks like if the county can't offer the type of programming that's available in, say, DuPage, Lake, Cook. So all we're asking for is a way, and we're very much open to how this looks, but a way for there to be a uniform standard so that every defendant in every county gets the same treatment when they get this program. Should have access to it.
I hear that. That sounds like a larger and different problem than the one that this bill is trying to address. And I guess I would just offer that for the counties where none of these programs are available to people pre-trial, the question of whether they count their sentence or not is immaterial, right? Because they're not participating in the programming. So I take your point, and I think that some sort of uniform standard for what kinds of programming is offered to people in pretrial detention is a great idea. And I think making sure that every county in the state offers programming to people in pretrial detention so that they can spend that time doing something gainful and productive is a fantastic idea, and I think it's a project we should all work on. But I think it's bigger and kind of separate and apart from this narrow cleanup of inconsistent application of a law that we already passed. Thank you.
Thank you, Leader Gazzardi. Did you want to? Any further questions on House Bill 4559? Members will be at ease just for a moment. Thank you, members, and committee is back in order. There being no further questions, Representative Gonzalez moves that House Bill 4559 do pass. Spokesman Winhurst. With partisan leave being granted, there being 9 votes in favor, 5 votes opposed, no. Zero voting present. House Bill 4559 is declared passed and be favorably reported to the House floor. Thank you, Representative Hernandez. We still we'll do Representative Laha. Oh, there's the
He's the one I'm already.
all right. The chair recognizes Representative Laha to present House Bill 4659. The floor is yours, Representative.
Thank you, Chairman Slaughter, Spokesman Windhorst, and members of the committee. I am asking to pass House Bill 4659 out of committee today with the promise to hold the bill on second and bring back an amendment for the committee to address all opposition. The bill will look different in that it will specifically be addressing coerced debt and financial abuse that many domestic violence survivors are subject to. I've been working with the Illinois Coalition Against Domestic Violence and the Sheriff's Association, advocates, and other members, and I intend to work with the network and the State's Attorneys Association and members of this committee to ensure the amendment brought back addresses all concerns. I would appreciate your support to get this important bill out of committee and bring it back with these specific changes. Thank you.
Okay. Looking at domestic violence policy.
Yeah.
Let's pause just for some witness slips. Representative, you have one proponent, an individual, Mr. Kreutzer. You do have two opponents, Illinois Sheriff's Association, Illinois State's Attorneys Association. Members, any questions on House Bill 4659? The representative is bringing the bill back with a promise to keep on collaborating. Representative Hawk, can you maybe just shed a little light on the opposition?
Sure. When we originally brought the bill, it was intended to basically address coercive control. Obviously, that's extremely broad, and we were told by opposition that we need to focus it a little bit more. So we specifically decided to address something that is not in the domestic violence bills that we already have, which is specifically coerced debt and financial abuse.
Right, so narrowing this down just to financial
Correct.
abuse.
Correct.
Okay, understood. Any
We're
questions?
just trying to close some of those loopholes.
Thanks, Representative Lahai. Any questions on House Bill 4659? Seeing none, Representative Sheehan moves that House Bill 4659 do pass. My side of the aisle, we okay with this? Yes, okay.
Yeah.
And it is, there being 14 votes in favor, 0 votes opposed, 0 voting present. House Bill 4659 is declared passed. Be favorably report to the House floor. Thank you, Representative Laha.
Thank you so much. I appreciate it. Thank you.
Okay, next we will hear from Representative Mussman on House Bill 5562. Representative, you already have an amendment on this. You want to go ahead? We'll adopt that amendment. Representative Gonzalez moves that the committee do adopt Committee Amendment 1 to House Bill 5562. All those in favor say aye. All those opposed say nay. The opinions of the chair, the ayes have it, and the amendment is adopted. With that, the chair recognizes Representative Mussman to present House Bill 5562. as amended.
Thank you, Mr. Chair and members of the committee. House Bill 5562 is an initiative of the Cook County State's Attorney's Office to protect child victims of torture. In 2019, the American Bar Association adopted a policy urging federal, state, and local governments to explicitly define child torture in statutes, especially as it may not necessarily manifest as physical abuse that results in great bodily harm, but still has a tremendous impact on a child's physical, mental, and emotional health. 37 states have such laws on their books, but currently Illinois is in the minority of states that does not. Today I'm joined by Yvette Loizen, Chief Assistant State's Attorney for Policy at the Cook County State's Attorney's Office, to discuss why this bill is needed and answer any questions. As many of you know, we've had very robust discussions with a variety of committee members. We would like the opportunity to hold this bill on second and come back with yet another amendment that can incorporate more of your recommendations. But we are here today to answer questions as it stands.
Okay, thank you, Representative Mussman. Let's pause if I can find this bill just for some witness slips. Okay, you've got 39 proponents. Cook County State's Attorney's Office, also Chicago Lodge 7, Child Advocacy Center of McHenry County, several individuals, Kane County Child Advocacy Center, Advocacy Network for Children, Lifespan, Cook County Public Guardian, American Academy of Pediatrics, you do have 2 proponents. ACLU of Illinois and the Cook County Public Defender's Office. Members, questions on House Bill 5562 as amended. What was that? I may have misspoke. Just the opponents were ACLU of Illinois and the Cook County Public Defender's Office. I'm sorry if I misspoke. Representative Mussman is bringing this bill back, requesting to hold this on second, to continue to incorporate uh, Leader Gazzardi on a question first, or Vice Chair Cassidy? You guys choose.
Thank you for for being here. Thank you for the time that we've all spent talking about this bill. I know that there are a lot of people on the committee with some concerns, in particular, just the fact that we don't do sentencing enhancements. We've not been doing those. I've appreciated the very specific conversations about the kinds of cases you're attempting to capture. So I'm just putting it out there on the record. I am going to vote to move it out of committee today. But I expect that when the amendment comes back, it's going to be extremely narrowly tailored to the kinds of cases you talked about that you've not been able to prosecute in the way that you would like to. So I want it to be very prescriptive and not overbroad. So I just want to put that on the record, and thank you for all the time that we've spent on this today.
Thank you for your feedback, Representative Cassidy, and it's been a pleasure working with you on narrowing this down. So thank you so much for your time.
Yeah, hi. Can you please state your name and organization for the record? I'm sorry.
Oh, I'm sorry. Yvette Loizon, and I am an assistant Cook County State's Attorney.
Please proceed, Leader Gazzardi.
Thanks, Mr. Chair. Thanks, Rep. Mossman, for your work on this of our discussion today, and to the Cook County State's Attorney's Office for our ongoing discussions about this bill, and echoing some of Representative Cassidy, Vice Chair Cassidy's concerns. I maybe just saying more explicitly the thing that she was implying, which is to say child torture is wrong and terrible, and we have a responsibility, I think, to be very cautious about when we create new Class X felonies because of the severity of that sentence, that the conduct that we're targeting with the conduct that could be sentenced to Class X should be the most egregious conduct there is. And of course, torturing children is some of the most egregious conduct there is. But I think that some of the conduct described in this bill doesn't rise to what seems to me to be that level of egregiousness. The conduct meaning, I'm reading now from the bill, at least 2 acts, including, for instance, the administration or threatened administration of mind-altering substances. And so, the bill also doesn't exclude, in fact, it explicitly includes the possibility that minors could perform this conduct, right? The last paragraph of the bill says that offenders under the age of 18 could also be sentenced in this way. So, this could be two teenagers, one of whom says, you better do this or else you're going to have to take this shot of vodka. And they say, I don't want to do it. And then they say, you really better do it or else I'm going to make you drink this. That's two instances of threatened application of a mind-altering substance to a minor, which could be just because of the way the word cruelly is defined in this bill. It's somewhat vague. It's could be described as knowingly and cruelly engaging in a course of conduct that torments a child under the age of 18 years. I understand that that's not the kind of conduct that any of us believe should be criminalized by this bill. So that's just a way of saying, I think that narrowing the scope of this to really, you've explained that there's a gap in our law where there are certain acts that you believe it's difficult to prosecute because our statutes don't allow for them. I'm open to that conversation, but I think the language as it's written is so broad as to encompass a wide range of behavior that doesn't seem to me to rise to the level of a Class X felony.
Thank you for the feedback.
Thank you, Leader Gazzardi. Representative, we've spoke outside the committee about this at great length. I know that you're coming back with it. We do have the Cook County State's Attorney's Office here. I know the American Bar Association is recommending this. I don't know how many other states have this. Can you give us some more context around the need for the bill and where this is coming from?
Yes, absolutely. There's 37 other states that have this legislation. That is why the ABA recommends it. I do believe one of those 37 is Washington, D.C., so maybe 36 plus Washington, D.C., to be accurate. Here are some of the scenarios that we are seeing coming through our courtrooms that we are feel we don't have the appropriate tools in our toolbox to make charges. We see cases where children may not be beaten, but they have been starved. We see cases where children are locked in cages. We see cases where children are tied up and put in dark rooms, dark spaces, dark closets. We've seen cases where kids have been exposed to extreme temperatures. One example I can give you, and I'm sorry, some of this is graphic. Our children that are forced to put on snowsuits, winter coats, boots, hats, and then spend extreme amounts of time outside in on very hot days. Conversely, cases where children are exposed to extreme cold in naked or semi-clothed states. So we have a lot of examples, and those aren't just from Cook County. We have examples from other counties as well. That's the gap that we're trying to plug. One thing I do want to be clear on is that in the course of conversation with many of you on this topic, we did hear the feedback about how some of the language is not tight enough. So we have gone back to the drawing board. I will say, with respect to the definition of cruelty, one of the things that we've done is look in Illinois law at other statutes that define cruelty, and we've looked in case law as well. And so those of you who are familiar with criminal statutes, you'll see that the language heinous, brutal, and indicative of wanton cruelty is a definition that's very firmly established in statute and very firmly established in case law and has been interpreted at length. That's a language change that we're prepared to make. We also are prepared to take out the language that involves the prosecution of juvenile offenders, and we are prepared to take out language that could make this a Class X felony for emotional abuse only. Those are some of the most serious issues that have been identified for us. There are other amendments that we are working on, but I do want to give you those examples so that you know we are hearing you, we are acting in good faith here, and we really are working towards cases that involve very extreme abuses of children.
Okay, thank you. Any other questions on House Bill 5562 as amended? Seeing none. And before we take the vote, just want to confirm, Representative Mossman, you are going to be holding this on second
Yes, absolutely.
to address all these concerns.
Yes, we will make every effort to address these concerns and circle back and talk with everyone about
the proposals being considered for feedback in the meantime.
Okay, with that said, there being no further debate, Representative Vela moves that House Bill 5562 do pass as amended. We've been granted there being 14 votes in favor, 0 votes opposed, 0 voting present. House Bill 5562 is declared passed and be favorably reported to the House floor. Thank you, Representative Musman.
Thank you, Chair and members of the committee.
Thank you. Permission to present from my chair.
Yes, please do. The chair recognizes Vice Chair Cassidy to present House Bill 5383.
Thank you, Mr. Chairman. I'm going to start from the top. House Bill 5383 will be back. And if it's not back, it's not moving. This is an initiative I've been working on with Senator Chapin Rose, and a retired judge from his area who has been working across the state to establish specialty courts specifically for DUI courts. And some of the circuits that he has been working with have said that they don't feel comfortable moving in this direction without specific statutory authorization. So we've been working on this since last summer. What we are trying to do is to make sure that none of the 6 existing courts are impacted negatively by any of the the boundaries that might be put in place around these. And so we are hopeful to come back with an amendment that does address that while maintaining the support from AIM and MAD, to make sure that folks can have a chance to do treatment for DUI. And that's what I got.
Thank you, Vice Chair Cassidy, especially for being a champion on these issues. You don't have any proponents. You do have two opponents. Illinois Sheriff's Association, Illinois State's Attorneys Association. Members, any questions on House Bill 5383, please know that Vice Chair Cassidy is holding this on second to continue to work on this. Representative Grail Crayar on a question. I'm getting better.
Yes, you are. I will acknowledge that. Thank you, Chair. Representative, is the goal that to bring this back is because you want to bring the opposition to a neutral, or what's the purpose of it?
Both. So we want to address the concerns. Most of the concerns come out of this same issue. So we've got the Kane County State's Attorney's Office is currently operating in a way that doesn't match this, and it's a very successful program, so we want to make sure that that gets to continue to operate. At the same time, we want to make sure that AIM and MAD stay comfortable with the language. So it's the classic, Jello mold. Poking it over here and it wiggles over here, and we're just trying to get the wiggles under control.
Thank you. Got it.
I love it.
It's all yours.
Spokesman Winners.
Thank you, Mr. Chairman. Vice Chair Cassidy, it appears that eligibility, as it's currently written, is the defendant must consent, and the judge, of course, must place the individual in the program. Does this require the state's attorneys to agree to the defendant being in the treatment court, or could that occur over the state's attorney's objection?
I don't believe it could occur over the state's attorney's objection. The language is very similar to all the other treatment courts in terms of how people come in.
And the end result, if a person is successful, what would occur?
Well, that's one of the things that we're likely to come back on, because there are some that do a full dismissal. There are others that keep a record, and we're trying to get everybody on the same page.
Thank you.
Okay, any further questions on House Bill 5383? Vice Chair has indicated that she is holding this on second, seeing none. There being no further debate, Representative Gazzardi moves that House Bill 5383 do pass. Okay, parts and leave granted, and there being 9 votes in favor, 5 votes opposed, 0 voting present. House Bill 5383 is declared passed and will be favorably reported to the House floor. Thank you, Vice Chair Cassidy. Okay, members, there being no further business this evening, the House Judiciary Criminal Committee will recess to the call of the chair. Have a good night.